is Kristen Osterhout. I am the Education and Training Coordinator for the Alzheimer's Disease Caregiver Support Initiative. So I have a couple of housekeeping notes. I do want to let you know that you are in a listen only mode right now, which means I cannot see or hear you. However, if you have questions, please type those into the chat box. We'd be happy to answer those. And I do want to let you know that this is being recorded and will be available for a replay in about a week or so. It should be on our website. So for those of you who don't know me, I work for the Alzheimer's Disease Caregiver Support Initiative. Our program goal is to improve the quality of life of caregivers and people living with Alzheimer's disease or other dementias. We're supported by a grant from the New York State Department of Health to serve Clinton, Franklin, Essex, Warren, Washington, and Hamilton counties, although there are other similar programs in every county in New York State. And the services that we offer start with care consultations. These are initial meetings with our care navigators to talk about your family or your individualized situation, how we can help, and they also connect you to other community resources. We also offer support groups. These are all happening virtually, either on Zoom or on the phone at this time. We're hoping to get them back in person in the fall, but we will still offer some virtual options for people who prefer that. Memory cafes, again, are social events that are happening virtually at this time. These are for both the caregiver and the person living with dementia. We'll hire a musician or get together and do a craft, and I'll deliver all the supplies. It's a really fun afternoon activity for people to socialize virtually. There is a limited amount of respite that we offer. So that is for caregivers to get a little bit of a break, be able to go get their hair done, go have lunch with a friend, go to their own appointments. However they would like to use it, they are welcome to use the hours that they're given. And lastly, we have something called Project Lifesaver, which is a bracelet that your loved one would wear. And in the event they were to wander and you could not locate them, work with emergency services to locate them quickly and efficiently. It has a 100% success rate and it is nationwide. So if you're on vacation, you could go use it in Florida if you needed to. All of our programs are free. They're open to the public. There's no income eligibility in order to enroll. All you have to do is call us up and say, I'm a caregiver for my mom, my dad, my husband, a neighbor, a friend who's living with dementia, and we will be able to help you out. So that's me, that's our program. And today we are going to be talking about advanced directives. So we brought in Debra Verni from Herzog Law Firm to talk a lot about this in more detail than I can. So I'm actually going to pass it over to Debra.
Good evening, everyone. It's great to join you here and help out Alzheimer's to inform you about all the things about advanced directives, everything you ever wanted to know, but were afraid to ask. How about that? So we're going to go through a few slides. And as Kristen said, if you have any questions, use the chat. We'll be happy to answer your questions the best that we can. And hopefully we'll get some great questions. So when we're talking about estate planning documents, okay, so we're talking about estate planning documents everyone should have, a healthcare proxy living will, a disposition of remains form. That's one a lot of people really haven't heard about. Durable power of attorney, which we're going to go into, and a will. So advanced directives. A lot of people, when they think advanced directives, they think, well, it's just a healthcare proxy. I've got one of those. I downloaded the form from the internet and I signed it and a couple of other people signed it, right? Well, that's an advanced directive. Also, advanced directives are do not resuscitate, DNRs, which a lot of people are really confused about exactly what a DNR is. A MOLST, an MOLST. A lot of people are not familiar with a MOLST. More and more people that I talk to are not familiar with them. So there's a lot of different advanced directives. So basically, it's something that you set up before you need it, right? Kind of easy. So when you're thinking about doing a healthcare proxy and you're thinking about who you're going to choose, you obviously want to talk to the person you're going to choose, and you need to make sure that that person is willing to do what you want them to do. Okay. If you've been diagnosed with an illness, if you've been entering assisted living or a nursing home, or that sounds really sad because 65 is such a young age, right? Or you've been admitted to a hospital, or you're over 65, you should have your estate planning done. People ask me all the time, when's the perfect time to do your estate planning? And I say, if you're 18 or above, you should have an estate plan. That sounds a little silly, but the sooner you get things done, the less you have to worry about them, right? So your healthcare proxy. So it's a really powerful document. This document allows a person to make healthcare decisions for you. Now, this document has to be witnessed by 2 disinterested witnesses, right? So what does that mean? So that means that the person has to have capacity to sign. And this is where I tell the story and people laugh. My husband fell off a 30-foot ladder, and they called the ambulance and they rushed him to the hospital. And, you know, he was doing okay. He broke a few bones and he's laying there in the hospital bed. It's like 2 a.m. And the nurse comes in and she's like, hey, does he have a healthcare proxy? And I said, well, yeah, he does. It's at home. And she goes, well, we can do one here. And I said, okay. And so she fills it all out and she says to him, so do you want her to be your healthcare proxy? And of course he went, which she assumed meant yes. So she wrote up all the documents. She goes, okay, so we'll make you his healthcare proxy, sign here. And I went, no, I can't be a witness because I'm appointed. She's, oh yeah, that's right. Okay, so just because someone's in the health field doesn't necessarily mean that they know what the document needs. So you have to have 2 disinterested witnesses, meaning someone that you haven't appointed on your healthcare proxy. So the person has to be 18 years or older, right, to be able to be your healthcare proxy. And again, it has to be someone that you trust, someone that's going to follow your wishes. And you have to understand, once you sign it and they sign it, their authority to begins, but they can't act until you can't act for yourself, right? So if you're in the hospital, you're in your hospital bed, I always joke saying, sitting there eating your Jell-O and talking and making decisions, then they're not going to look to your healthcare proxy to make your decisions. They're only going to make your healthcare proxy make decisions for you if you can't make them for yourself. So just remember that as long as you're competent to make your decisions, your healthcare proxy doesn't have any power. You may have the document all set, you may have it on file, but they can't make decisions if you can make them for yourself. So again, what's their authority? So what happens? Right? So if you don't have a healthcare proxy and they rush you to the emergency room, right, they're going to look to your next of kin to make your healthcare decisions, which a lot of times that's okay, right? Because husband, wife, kids, whatever. But what if there's an argument, right? What if it's a second marriage? What if this person, they rush you to the hospital and you've told your new husband one thing and you told your kids another thing, and they get into a big argument at the hospital as to how you're going to be treated. Well, in New York, they can actually make your healthcare decisions by committee. So what does that mean? That means that if there's a big argument and they basically can't get any clear direction, they can meet in committee, the doctors and nurses, and they can make your healthcare decisions. So you really need to make sure that your healthcare proxy is someone that you trust and someone that you give clear direction, and you actually execute a document. You don't just say, hey, if I end up in the hospital, I want you to make my decisions. You really do need a document. And you need to understand that if you are someone's healthcare proxy, you're not financially responsible for anything that happens. So if they need surgery and you say, yeah, they need surgery, and then come to find out they don't need surgery, or let's just say the insurance doesn't pay for it, right? They can't come back to you as a healthcare proxy and say, hey, you should have never ordered that surgery for this person. You have to pay for it. They can't do that. There's no financial responsibility. So be clear, okay? the healthcare proxy is making healthcare decisions. Your living will is the document that's end of life. Okay. But you need to be clear to the person that you've appointed, right? Do you want CPR? Do you want a feeding tube? Do you want maximum relief? Do you want pain meds? And do you want to donate your organs? Because a lot of times, if you want maximum relief, right, some of those meds that they give you for maximum relief are going to taint your organs, as it were. So I guess you kind of have to decide between one and the other. And I also tell people, I'm dating myself now, but remember the Terry Schiavo case, right? Terry Schiavo case, the parent said this is what she wanted. The husband said, no, this is what she wanted. And there was an argument back and forth and back and forth. It was tied up in court for years and years and years. And all the time, this poor girl just sat there, right? And they couldn't make decisions as to whether they were going to basically pull the plug, right? So think about these things and make sure that you have your documents, make sure your documents are clear, and make sure the person, I can't stress it enough, will do what you want them to do. Because what you have to understand is a healthcare proxy living will does not have any teeth. Okay, if you have a healthcare proxy living will and your living will says, if the doctor comes out and says, I'm not coming back, give me good drugs and let me go. But they talk to the person you've appointed and they say, this is what's happening. And if they say, hey, I've seen her come back from worse than that, give her everything that you've got, they're going to follow that person's direction. They're not necessarily going to follow your direction. So living will kind of lead into living will, right? So these are going to say whether you want artificial nutrition, hydration, CPR, if you want to be on a ventilator. I had a lot of clients that had basic generic living wills and healthcare proxies at the beginning of COVID. And unfortunately, COVID's not over yet. Their issue was that, hey, what if I'm rushed to the hospital and now my person, right? My person can't get into the hospital. They can't make decisions for me. And what if they have a copy of my living will and it says, I don't want to be on a ventilator, but now I have COVID and I need to be on a ventilator, right? So who's going to be there to make those decisions? And it's happening again, where a lot of the hospitals are not letting your person go in with you. So you need to make sure that your documents are clear and what you want, because your person may not be there to be able to make decisions for you. Do you want to be on a feeding tube? Do you want to be kept alive on a feeding tube? How long do you want to be on a feeding tube? How long do you want to have hydration? Okay, are you going to limit it? Or is it just going to be a generic, hey, if the doctor says, I'm not coming back, give me good drugs and let me go? You need to be really clear with the person that you've appointed, because they're going to be following your direction, hopefully. And you've got to be clear as to what the situation is so that you make sure that they understand what's a yes and what's a no. What's a hard no? What am I not coming back from? So you've got your documents done, right? You've got your healthcare proxy, you got your living will done. Where are you going to keep them? Well, as I said, when my husband was rushed off to the hospital, we had them at home, but it was a little bit late for that. So a lot of people will put copies in their glove compartment. Again, wouldn't have done me any good, but a lot of people will put copies in their glove compartment. A lot of people will put pictures of them on their phones, right? That kind of makes sense. I know a lot of people that have taken pictures of their vaccination cards for COVID. Why not take a picture of your healthcare proxy living will, right? So you have it on your phone. And if you're the person appointed in someone's healthcare proxy and living will, more than likely you're the one that's doing their doctor's appointments and stuff with them, and you're the person that they will call if they were in the hospital, you should probably have copies of their documents on your phone. Just kind of a thought. If you don't want to carry your phone or you don't want it on your phone, you need to make sure that they're accessible. I have some clients that will put their healthcare proxy living will on their refrigerator, right? So if something happens, the person that's running out with them can just grab it off the fridge and they have it with them. It sounds kind of weird walking into somebody else's house and you see their healthcare proxy living will hanging on their fridge. But if you've got a situation where a person ends up going to the hospital a lot, that's probably the place to do it. Also, I tell my clients as soon as they execute their healthcare proxy and living will, they should take a copy into their doctors and have it scanned into the cloud. I know a lot of the doctors in Saratoga, where I live, have all of the documentation scanned into the cloud. So if I was rushed to Saratoga Hospital, they could pull all my information down and they would know who they need to contact. That's another thing. You need to make sure that the person you've appointed's phone number, right? Your phone number is on the healthcare proxy living will, because how are they going to find them? I mean, it's one thing to have an address, but people have gotten rid of their landlines, right? So if they have a cell phone, you want to make sure that that person's cell phone is on your documents so that they're able to contact them. So power of attorney. A power of attorney is even a more powerful document than a healthcare proxy, but a healthcare proxy can't make financial decisions for you, and a power of attorney can't make healthcare decisions, right? So it's kind of a trade-off. A lot of times people have the same person as their power of attorney and their healthcare proxy, and sometimes they don't. But a power of attorney is a very, very powerful document. Once you sign it and the person you've appointed signs it, they can literally do anything that you can do. But again, the person has to be competent to sign a power of attorney. So what does competency mean? It means they have the ability to know what they're signing and that they're appointing someone to make their financial decisions for them. And again, it needs to be witnessed by two disinterested witnesses. So do any of these documents have to be done at a law office? No, they don't necessarily have to be done with a lawyer. The healthcare proxy living will, you can download those from the New York State Bar Association website. The power of attorney, they just came up with a new form as of June of this year. A power of attorney, because it's such a powerful document, I always suggest that you have an attorney help you with it, but just make sure if you decide to do it yourself that you get the form that's from June 2021, right? Because the other forms are kind of obsolete right now. And by using one of the old forms, it's not going to be a valid power of attorney. You also have to have it signed by two disinterested witnesses, meaning anyone that you appoint in your power of attorney cannot be someone that is a witness, right? Undue influence, right? You sign them as your power of attorney. Now they have control of all your finances and they were a witness. Not a good thing. So the person that you appoint also has to sign. So the person who is the principal, right? The person appointing the person and the agent, both of their signatures have to be notarized. And the agent or the principal's signature has to be witnessed by two witnesses. And the witness and the notary can be the same person. So what can a power of attorney do? Power of attorney can open accounts, close accounts, change names on accounts, change beneficiaries on accounts, transfer real estate, amend trusts, transfer your money. Talk to your insurance company, which is really important, right? Your healthcare proxy is the person that's going to talk to the doctors. Your power of attorney is the one that's going to talk to the insurance company. Hey, is this covered? Do we need a second opinion? They're also the person that's going to be able to talk to the company that holds your retirement benefits, that if you're unable to take care of things, that they can make sure that you're getting the money that you need to, and file your taxes. So it's a very, very powerful document. So remember, the power of attorney, once you sign it and the person you've appointed signs it, they can do anything that you can do, right? Like the old song, anything you can do, I can do better. Well, they can. So you got to be careful who you appoint. You can appoint co-powers of attorney so that they both have to sign together. You can appoint either or, so Sally or George, or you can appoint Sally then George. So there's different ways you can appoint people. I've found that in the past, a lot of people, husbands and wives, appoint each other, and then they appoint a child, right, as a backup. Well, the only problem is that mom and dad are around the same age. We're all aging in place right now. And so whenever mom or dad has a cognitive impairment, we have to redo the power of attorney so that the kids can step up, or the parent has to resign. So if instead of that, they just had, mom appoints dad or Sally, then if dad became incapacitated, then Sally would be able to act. We wouldn't have to have dad resign. Just kind of a thought, kind of a side note. So disposition of remains form. You guys are like, really? Why would I want to appoint somebody to be in charge of my body once I'm gone? It sounds really silly, but again, we get into a lot of issues with families with second marriages, right? So dad dies, mom says to the kids, hey, whenever I pass away, I want to be buried with dad. Then she gets remarried and then she passes away. And then guess who's in charge? New husband, right? And he's going to be in charge of her remains. So if she wanted to make sure that she got buried with her first husband, she needs to do a disposition of remains. And we always joke and say, this keeps people from fighting over your dead body. But it does. Also, what you need to think about, and a lot of people don't, is that whenever you're married, even if you're in the middle of a nasty divorce, that ex-spouse to be is the person that's still going to be in charge of what happens to your body. We had a situation actually in my office. It was one of my clients. We were doing Medicaid for mom, and we were working with the son to get mom on Medicaid. He was in the middle of a nasty divorce and he passed away. Okay, so the ex-wife to be had him cremated and then called our office and asked how much mom was willing to pay, right? Willing to pay for his ashes. Is it extortion? Yeah, but she was in charge. So mom ended up paying $5,000 to get her son's ashes so that she could bury them with the family. So again, a disposition of remains form is, it's an important form, especially if you have kind of a non-nuclear family, or if you have specifics, right? I want to be rolled down the aisle with trumpets blazing and yellow roses. That's all stuff you can put in this document. Or, I want my ashes scattered here or there. So that way people know exactly what you want. So DNR. Okay, so a DNR is a medical form. Attorneys cannot do DNRs. Only doctors can do DNRs. And it's kind of interesting because in the healthcare proxy living will that we prepare for clients, our living will says, I would consent to a DNR. So a lot of people I do documents for, they call me up and they're like, hey, I don't want this DNR in here. I'm like, it's not a DNR. It says you would consent to DNR. They don't let attorneys do DNRs. So you need to understand what a DNR, right? So when you're saying do not resuscitate, that means no chest compressions, ventilation, defibrillation, no intubation, no medications. That means give me good drugs and let me go, right? So there's two different types of DNRs. There's an in-hospital DNR, which kind of makes sense, right? It's in hospital, signed by a doctor. And there's out-of-hospital DNRs. And an out-of-hospital DNR is exactly that, right? It's a form that's signed by the doctor that says do not resuscitate. What you need to understand that even if you have this really cool bracelet that's in this photo, right? Because you can get them on Amazon. If you do not have a written DNR, they're still going to resuscitate you, right? The paramedics show up, they see the bracelet, they'll say, cool, nice bracelet. Where's the signed document from the doctor? You don't have one, they're going to resuscitate you. So you need to know, even if you have the cool bracelet, they're still going to resuscitate you if you don't have the document that's signed by a doctor. So a MOLST form. A MOLST form is a bright, bright pink form. It's brighter than the picture there. Almost like the color of my sweater, but more pink. Anyway, it is a medical order that's signed by you and your doctor. So a MOLST form is a form that if you want it, you actually have to make an appointment with your doctor to meet with them and sign it. So who is going to do a MOLST for? So a MOLST form is medical orders for life-sustaining treatment. So why would you want to do a MOLST form? A MOLST form has teeth. In other words, even if you have someone appointed and they say, no, she wants to be resuscitated. If you have a MOLST form that's signed by you and your doctor, they're not going to resuscitate you. So why do I need a MOLST form? I had a friend who had brain cancer, right? So she had brain cancer, they did surgery, they couldn't get all of the tumor. And she knew that she was going to pass away. And she had seizures, right? And she didn't want to be resuscitated if she seized. And so she did a MOLST form and she hung her MOLST form on the refrigerator, because if someone called the paramedics, which obviously someone's going to, if you're in a seizure, right? They're going to call somebody, they want help. that MOLS form was there so that if she did arrest, then they would not resuscitate her. That's something you got to think about, right? She had all kinds of issues that went with her illness, and she did pass away. But if you know you're going to die within a year, of course, no one has a crystal ball, but if you have some kind of illness that you know is terminal and you're going to die within the year and you don't want to be resuscitated, then this is the form that you need. Again, people are like, well, how old do I have to be? What kind of situation is it? If you have questions, talk to your doctor. But if you're going to sign one of these, you need to make sure that you don't just show up at your regular appointment with your doctor and say, hey, while I'm here, could you do a MOLS form for me? Because they've got a budget time, because they got to go over everything with you, what you do want, what you don't want, and you sign it and the doctor signs it. See, I jumped ahead of myself. Anyway, so they have to sign it. And the reason a lot of people do MOLS forms is because it is good between places, right? So let's just say that you have a in-hospital DNR, but you don't have an out-of-hospital DNR, and they're transferring you between the hospital and a nursing home, right? And you code, what are they going to do? They're going to resuscitate you, right? Because you're not in the hospital. If you have a MOLS form, right, it's doctor's orders. So whether you're in a nursing home, whether you're in an ambulance between the nursing home and the hospital, the MOLS form is going to carry you between those facilities. So definitely a good document to have if you want to make sure that they're going to follow your wishes. So your will. So a last will and testament. I know a lot of you are like, I've got one of those, or I don't have enough stuff. Why should I have a will? So a will gives direction as to where you want your stuff to go whenever you pass away. And it's really the foundation of any good estate plan. What you need to know, and we'll go into it in a couple more slides, is that when you have a will, right, you're giving direction as to where your stuff goes and who you want to be in charge. If you don't have a will, the state of New York is kind of going to decide where your stuff's going to go. And we have a question. What is the difference between DNR and MOLS? Renew every 6 months. So a DNR generally has to be renewed. A MOLS form doesn't. The documents themselves say that they should be renewed every 6 months. If the paramedics come in, they're not going to look probably to see if it's been 6 months. I know my friend had hers, and it was over 6 months whenever she passed. But the reason they do the every 6 months is because if you have a DNR, maybe you changed your mind, right? Maybe you don't necessarily not want to be resuscitated. Maybe your health has gotten better. And it's just like any other document, right? It's a fluid document while you're living. So you need to make sure that you update your documents if at all possible. And that's the thing too, if you're competent to update your documents. If you don't have the competency to update your documents, then obviously they're going to have to let your documents stand. So, but a great question, thank you. So what about your last will and testament? So who are the parties of your last will and testament, right? So your beneficiary, that's the person that's going to get everything. Could be friends, families, charities. Executor. The executor is the person that collects up all your assets and distributes them to the beneficiaries. Everybody's like, well, who should I choose as my executor? And I always joke and say, probably somebody you don't like, because it's really a thankless job, right? You're kind of stuck in the middle between everybody else. Executors really kind of get the brunt of everything because you've got family members fighting, who got this, who mom loved best. Make sure that it's someone that can balance a checkbook. I know people don't balance checkbooks anymore, but make sure that it's a person that's good with facts and figures, because this is the person that's going to have to track down all of your assets, collect them all, and then distribute them accordingly to the beneficiaries. Now, probate process. A lot of you have heard of probate and you're like, ugh, probate, what's that? I hear it's this awful thing. So probate is to prove, right? To prove the will. So in order to probate a will, we have to have the original will, and we have to have a death certificate. We have to have a family tree, and all this paperwork has to be filed with the court before they'll appoint the executor, who's the person that's going to collect up all the assets and distribute them. So what if you don't have a will? Okay, so what if I don't have a will and I pass away. Well, it depends, right? If you don't have assets individually in your name, okay, so a will only controls assets you have individually in your name whenever you pass away. So if everything's joint or has a beneficiary or it's in a trust, your will never have to be probated. Okay. That being said, if you don't have a will and you pass away, they do what's called an administration proceeding if you have assets individually in your name. And state of New York says, okay, so we look at who the beneficiaries would be. So we look to see, do they have a spouse? Do they have a spouse and no kids? It's all going to go to spouse. If they have kids and no spouse, it's all going to go to kids. What if they have a spouse and kids? Okay, then it's going to be $50,000 to the spouse, and the remaining goes half to the spouse and half to the kids. And you're like, well, that doesn't make sense. No, it doesn't make sense. We had a situation in our office where there was no will. The husband and wife, married, obviously. They had put the house just in her name because he had a job where he could get sued. So they put the house just in her name, and then she passed away. No will. And so the son and daughter, the son says, hey, Dad, it's your house. We'll just deed it over to you. The daughter was like, no, I'm entitled to half. I want my money. The daughter actually took the dad to court to get her piece of the house. It was very sad. Obviously made it difficult for family functions, but she got her piece of money. He finally sold the house and gave her money. So no spouse, no kids. It's going to pop up to parents, no parents. It pops down to brothers and sisters, nieces and nephews. It goes all the way down to first cousins once removed, right? So they take a brick, whoever's head it lands on, that's who inherits your money. So we have another question. I can't get over there to the question, but there it is. Can a PO have the power to amend a testamentary trust? So a power of attorney can amend a trust. A testamentary trust, though, is a trust that's not established until someone passes away. So if the person's already deceased, no, the power of attorney loses their power when a person passes away. But if you had a revocable trust or an irrevocable trust and the person was still living, yes, the power of attorney could amend their trust. But a testamentary trust is a trust that's not established till after the person passes. So a testamentary trust would be a trust like, I leave everything to my kids, and if my kids pass away before me, then it goes to my grandkids. And if my grandkids are under 25, it goes into trust. So that would be a testamentary trust. And a power of attorney can't change a will. They can change a trust, but they can't change a will. So that's really a great question because it just depends on what kind of trust it is. But if it's an inter vivos trust, meaning a living trust, then yes, a power of attorney, if those powers are allowed in the power of attorney, can make changes to a trust, but they can't make changes to your will. So as I alluded to in the other slide, if you have everything joint or it has a beneficiary or it's in a trust, then the will would not have to be probated. Okay, so generally real property like a house or something like that is what throws somebody into probate. Because let's just say, okay, husband and wife, everything's joint, husband passes away, everything goes to the wife. So now the wife passes away. Well, you can put new beneficiaries on bank accounts, on retirement accounts, on life insurance, but you can't put a beneficiary on a deed, right? So the house, usually when the second person dies, is what throws us into probate. So make your accounts joint, or you can make your accounts at the bank. You can go in the bank and make the accounts TOD, which is transfer on death, whomever you make the beneficiary. So for instance, let's just say I named my son Zach as the beneficiary, TOD, transfer on death. He has no access to that account until I'm gone. He'd get the death certificate from my funeral director, and then he would go to the bank and cash out, but he has no access to it till I pass away. So make sure that your retirement accounts have beneficiaries, and then they have contingent beneficiaries, meaning backup beneficiaries in case something happens. Life insurance, again, beneficiaries and backup beneficiaries, or you can do a trust. A trust is something that also avoids probate. So a trust, right? It's a contract between you and the trustee. So as I said before, testamentary trusts are the ones that are inside your will or a trust, and a living trust is one that you're creating while you're alive, an inter vivos trust. So depending on what your goals are, there can be a lot of different types of trusts. The nice thing about a trust is privacy. And you're like, well, privacy, what do you mean? If you have your assets in a trust and you pass away, the trustee steps up and goes, hey, okay, call the realtor, let's put the house on the market. Whereas if you have a will and it has to go through probate, that takes a little while. And also it becomes public record. So for instance, those of you that are familiar right now, Saratoga Racetrack's going on, right? So Mary Lou Whitney, a lot of you are familiar with her will was probated in the Saratoga County surrogate, right? So it became public record. So when it became public record, everybody jumped on that, right? And it was all over the papers, who got this, who got that, how she treated people differently. If she'd had a trust, then that would have never been probated and no one would have known, right? Also, they said she had property in Kentucky and Florida and New York. And so they were probably going to have to probate her will not only in New York, but Kentucky and Florida. Whereas all of those properties, if they had been in a trust, again, trustee steps up and says, here's yours, here's yours, here's yours, call it a day, right? You don't have to go through the courts. These are great. We're getting lots of questions. Does anyone have the power to change a trustee? The trustee can be changed by the person that set up the trust. So you can amend the trust, and the power of attorney, again, it would just say whether they have the power to amend a trust. So in the new powers of attorney, one of the modifications is that the person can amend a trust. So yes, they could amend a trust. Whether they could remove a trustee, that's a very good question. It would depend on how the trust is worded. It would depend on the power of attorney and how that was worded. But definitely an excellent question, because you want to make sure that everything's protected, right? And the person that you've named continues to be the person that you wanted in the first place. So these are kind of like the highlights between a trust and a will, right? So the trust doesn't go through probate. The will goes through probate and delays. So what kind of delays are we talking about? During COVID, back in March of 2020, everything shut down, right? But it was nice weather, so it really wasn't a huge deal, right? So if someone passed away and we couldn't get letters of appointment to take care of things, not such a big deal. The pipes weren't going to freeze or anything like that. But if somebody passes away in the middle of the winter and there's no cash, right, to take care of things, who's going to plow the snow? Who's going to pay the utilities? Who's going to keep things going? Well, we go through the probate process, which in a simple one can maybe be appointed in a couple of weeks. In long-term ones, I mean, we've got 3-4 months before we can get somebody appointed, sometimes even longer. I've had a year before I was able to get somebody appointed. And we did have the pipes freeze and we did have issues. So that's just something to think about. The trustee would be able to have access to money and be able to distribute the property or sell it. The trust, again, it's a living trust, so you can put assets into the trust while you're alive. And then if you became incapacitated, the next trustee could step up, right, and take care of everything for you. The will doesn't take effect until after you passed away, right? So your executor has absolutely no power till you're gone. The trust says there's a backup trustee. So if something happens to you or your trustee, then the next person steps up. So we need to try to find a deep bench, right? We need to make sure that we have ourselves as trustee and then someone else as trustee, and then maybe a third person. Same thing with your power of attorney and your healthcare proxy, right? What if something happens to 2 people? Do you want to have to redo your documents? We try to, again, have backups, right? You need to make sure that you have backups. Trust, your financial affairs become private, right? They're private. They don't have to go to public, whereas the will is public. And so if you're kind of interested right now and you're like, my neighbor passed away a while back, or my cousin or my brother or somebody, and I wonder where their money went. If their will had to be probated, you can go down to the surrogate's court. I would call first because they may not be open. And you could go down and find out exactly what happened to everything. It's harder to contest a trust. Well, what does that mean? So let's just say you have a situation where I was married a man that had 2 kids from a prior marriage. We have 1 kid together, and then he dies and he leaves everything to me. We have to probate his will. So we go to the courts, and the courts say, well, you have to notify intestate distributees, which would be the people that would take if you didn't have a will, right? We're going back to New York law. So we have to notify the 2 kids from the prior marriage. They have to sign what's called a waiver. And then our son has to sign a waiver. Well, his kids are like, no, she had her foot on the oxygen tube. She made him sign the will. He loved us more. He wanted to give us all of his money. They could come in and contest the will, right? Because we have to have them sign this document. If they don't, we have to invite them to court, basically. If it's a trust, basically the trustee just gives me the money and everything's great, right? So that's kind of the difference between a trust and a will. Trust is a lot easier, takes less time. A will, a little bit more cumbersome. Remember, right? People don't plan to fail, they fail to plan. And sooner is better than later. The sooner you can get your documents done, even if it's just basic documents, the better off you are, because no one has a crystal ball, right? You don't know what tomorrow holds. Hey, my last slide. So if you'd like to call us up, we can sit down with you, look at your documents, tell you whether they're good, bad, or ugly. And if you want to go to our website, we have webinars that are already recorded. If you want to learn more about aging in place or anything like that, you're welcome to go. Or we have a radio show on Saturdays, and you guys can plug into the radio and listen to us. It's a call-in show, and you can also call in and ask questions. And it looks like we have another question. So, can a legal document established in New York be honored in Florida? Yes. So if you do your estate planning documents in New York and then you move to Florida, or I have a lot of snowbirds, right, that go to Florida for 6 months. A lot of my snowbirds actually have New York healthcare proxies and powers of attorney and Florida healthcare proxies and powers of attorney. New York documents are good in Florida. Florida documents are good in New York. It's just that when you go in to use them, the place is probably not familiar with that document. And they'll be like, oh, it looks fine, but we have to run it by legal. So your will and trust you do in New York and Florida are reciprocal. You don't have to redo those if you move someplace, but I always tell people if they move to a new state, you definitely should redo your healthcare proxy and power of attorney.
Thank you so much, Debra, for that wonderful presentation. I know I learned a lot, which is always good. I do want to say we did a conference a few weeks ago now with a presenter named Jim Comer, and he asked the audience, we did a poll, how many people had like healthcare proxies and wills and that kind of thing for their loved ones living with dementia, and most people did. But most of them did not have them for themselves. So I really do want to encourage caregivers, if you're watching and you don't have one for yourself, that's really important too, because no one has a crystal ball. We don't know what's going to happen in the future. And I also have another thing, totally kind of changing subjects, but I'm sure you're familiar with the 5 wishes. For people who are watching and are not familiar with this, it's just a booklet that goes through a really gentle way to talk about your end of life plans. I know it's a really challenging subject. People don't want to talk about it. But I plan to go through this with my mom on a personal note. She recently told me she wanted me to be her healthcare proxy. I'm the oldest daughter, so it makes sense. But it's just a gentle way to talk about it. And we have copies of these at the Caregiver Support Initiative. So if anyone's interested, just let me know and I can pop one in the mail for you. Are there any other questions?
Very quiet group.
We got all the questions done throughout the presentation. Well, thank you all for coming, and thank you, Deborah, for your presentation. Next week, we're doing a second part of this. Okay. I see someone's interested in getting copies. Okay, I will be in touch with you to get your address. Let me just make a note here. Yeah, so next week we are doing a part 2 about I think it's about financial planning. Sorry, I drew a blank there, but yeah, we're going to be talking about financial planning next week. So I hope that I see you all there. Oh, there is someone, we got a question right at the end, Deborah. If you do a TOD on a bank account, can a POA, power of attorney, access these funds?
Yes, they can. TOD is just transfer on death. So if you have a power of attorney that is doing your finances for you, they could open that account, they could close that account. I mean, they can do whatever they want to with it. So you need to make sure, again, that the power of attorney is someone that you trust, because they'll have control over that. And if you had that account kind of earmarked for that beneficiary, then they could change it, or they could take the money if you needed it for your care. And TOD is a great thing, like I said, but it doesn't really protect the account. It just makes it easier whenever someone passes away.
Yeah, that's a great question.
Mm-hmm.
Well, thank you, everyone. If you have any other questions, feel free to get in touch with me or get in touch with Deborah. And I hope to see you all next week.
Thank you.
Have a good evening. Thank you.